And for the defendant?
Yes, Wade Causey, Your Honor, on behalf of defendants Palestino.
Great, thank you. All right, so I guess two things here to start with. The first is I reviewed the motion to amend, the response, and the reply. I figured since we had the status conference, and if you feel comfortable, I can hear some argument on that. If there's any argument that either party would like to present. And then the other issue is we need to discuss resetting trial because the other trial that I have is going to go forward. So I suspect that it'll probably be best to discuss the motion to amend first, and then to discuss finding a new trial date. Thoughts on that, Mr. Connolly?
Sure, that's fine.
Okay, Mr. Causey.
That's fine, Your Honor, yes.
All right, so let me hear then first from you, Mr. Causey, as it is your motion.
Yeah, I think there's two key points here. And the first one is, when did the cause of action accrue? And it didn't accrue until my client was denied reasonable access under the CCRs to go in and repair the wall to the access to the adjacent property by the plaintiff. Once that denial took place, then a claim has accrued. Had they been given permission, reasonable access to go forward with repair of the wall as required under the CCRs, we wouldn't have a cause of action. And the wall would be fixed, repaired. My client's contractor would fix it. He'd pay for it exactly as anticipated or called for potentially under the contract. So really, the first and most important aspect of this is, when did it accrue? Because that determines whether there's been any delay tactics or anything on my client's part. Well, my clients don't want the claim. They want to fix the wall. So there clearly hasn't been any conduct on my client's part to cause any type of delay. They only seek this legal remedy because they have no other choice. The concern that I have is that if the court denies this in this case and we go file a separate action, I anticipate the defendants are going to argue in the other case that this was a claim that had to be brought in the previous case, and therefore try to have that second one dismissed. So I mean, obviously my clients are entitled to a legal remedy. I don't think even Mr. Connolly in the briefs has argued that they're not entitled to bring the claim. They may contest the claim, but I don't think that it's even being argued that they don't have any right whatsoever to bring the claim. So there's got to be a forum for it, and I think that this is the most likely forum to get the right result, because we're not going to wind up with any type of, I'm not entirely sure, Your Honor, we could have inconsistent rulings on this issue between two different courts just because of the way the claims are being made. So I don't want to argue that because I can't really, I guess it could happen. I mean, I hate to predict what either the court or a jury might do in either case, but I think it clearly is a claim that needs to be brought in this matter as it pertains to the wall, it pertains to the same parties. We don't have to bring any new parties in, and we're going to have to reset the trial date anyhow, and I don't believe there'd be any. I anticipate just from a discovery standpoint, we're not trying to open up discovery on the other claim. The other claim's just damages, and we didn't retain any type of witnesses or experts regarding the damages claim, and that was on purpose. We just didn't think it was necessary or that it was economically appropriate. So the only thing I would,
how much discovery is going to be necessary in your mind?
I don't plan
if the
on
court
taking
permits
any
amendment.
I don't plan on taking any at this point, depending on the disclosures. I anticipate there'd be a disclosure regarding the counterclaim, which would be my client's damages. but otherwise, there'd probably be a witness from the HOA to verify the approval of the repair to the wall. My client submitted his contractor's the contractor's work order, or whatever, the contract itself for the repair, the estimate, if you will, the details of it were submitted to the HOA. So probably an HOA witness is all I would add. And then maybe a real estate agent regarding damages.
How you respond to plaintiff's claims that this is a form of delay because your clients waited so long to respond to plaintiff's efforts to get the ball rolling on this repair, that this bridge could have been crossed way earlier. And so even though the denial of the access was more recent in time to when you file your complaint, such bridge could have been crossed years ago if your clients had been more responsive to their initial requests to get the wall fixed. I mean, that's what their argument is in terms of delay.
Understand the same reason we're going to trial in this case, Your Honor. It's the exact same reason. They've always tagged a bunch of additional claims onto repairing the wall. These claims regarding lost rent damage, claims regarding insurance addition, adding building permit claims for $3,000 to a wall that's being repaired. It's not a new construction. It's the add-ons. And the only way my client could concede was to concede everything. And they weren't willing to do that. They had no problem, as the court knows, on the negligence claim, readily admitting that they caused the damage to the wall. We did that at the motion for summary judgment stage. It's the additional damages that were always tagged onto that. In fact, there's email exchanges as part of this motion that talk about the exchange between counsel and I about what the effect would be on the claim if they were to have allowed us to go forward and repair the wall. And I put forth my view, nothing. We're not asking for a release. We're not asking for anything. I think the only effect it would have had on the claim is we would have been able to prove it's already been fixed.
Okay. And what provision of, well, let me rephrase this. So the court does not have to grant leave to amend. That would be futile, correct?
I'm sorry, say that again, Your Honor. I missed the middle part.
Court doesn't have to grant leave to amend for claims that would be futile.
Oh,
correct in a general sense?
Yes, I would think so. Yes. I didn't
So
really.
Can you explain to me what the basis is for the breach of contract?
Oh, they're required under the CC&Rs, which the court's already ruled this is a contract action, and the attorney's fees claim between the parties, the claim to get the fence repaired. Under that same portion of the CC&Rs, they're required to provide us with reasonable access to do so. And their failure to do so is a breach of it. No different than their claim that we're breaching for not fixing the fence.
Anything else before I hear from Mr. Connolly and Mr. Causey?
Nothing else, Your Honor.
Thank you. Mr. Connolly.
Thank you, Your Honor. Touching on the last point first, this claim of obligation to provide reasonable access, that was provided to the defendants for years, since 2022, years before this litigation ever commenced. My client was asking, indeed begging, for them to lift a finger and do something with regard to this case. Defendants have now used that intransigence and refusal to engage in any collaborative or constructive work with their neighbor as both sword and shield to now engage in discovery, retain experts, a real estate agent, long after all of the deadlines have passed. This is a case where the defendants did nothing for 2 years during the pendency of this litigation. No depositions, not even the submission of a uniform interrogatory, let alone a non-uniform interrogatory. No request for production of documents, no request for admission. Defendants have been asleep at the switch for 2 years during this litigation and for 2 years before this litigation, while this wall continued to crumble and now constitutes a physical danger to the inhabitants of the Johnson property. You also heard Mr. Causey say at the beginning of his argument, Your Honor, they just want to fix the wall. Those were his exact words. Again, 4 years of nothing. 4 years of not lifting a finger to assist Mr. Johnson in repairing this wall, filing an answer to a complaint, denying liability, submitting disclosure statements, denying liability in this case, submitting a response to a motion for partial summary judgment, which denied liability, but it carved out a small exception with regard to tort claims. They denied liability for any contract-based action in the dispositive motion, which this court granted. Defendants filed numerous motions early this year, 6-8 months after the discovery deadlines passed, asking to reopen discovery. The court denied it wisely, asking to engage in additional motion practice, additional motions for summary judgment. They wanted to file additional dispositive motions. The court wisely denied it because it was months overdue. They are now attempting to use this incredible delay, Your Honor, this incredible delay, and the court's issue with overlapping trials to reopen discovery, as they just acknowledged, and to take another bite at this litigation after being asleep at the switch for years. It's frankly rather outrageous. As I pointed out in my motion, in my response, Your Honor, if the decision to, if the predicate to amend a complaint is based on nothing more than the personal choices and elections of the moving party, the court is well within its right to deny that motion to amend, and that's what we have here. We don't have defendants saying, oh, well, Your Honor, the court ruled against us in a dispositive motion, so we're now going to buckle under and we're going to do what we should have done 4 years ago. You're not hearing anything about acting in allegiance with the court's order or attempting to work collaboratively with the plaintiff. Why do they want to fix the wall? Because they want to sell their house. That's the only reason that they're doing this. And that is a personal choice. That is an inconvenience that has befallen them because of their unwillingness to even engage in any neighborly or collaborative conduct for a period of 4 years as it relates to Mr. Johnson. The futility argument, they claim punitive damages in this case, saying that my client is guided by has an evil hand and he's guided by an evil mind. It's preposterously futile, Your Honor. No reasonable jury would ever conclude that my client was acting with an evil hand guided by an evil mind when he's the one who has been attempting to get the defendants to wake up and work collaboratively to resolve this matter. Further, the language of the proposed amended answer and counterclaim itself is preposterous. They're claiming that fixing the wall is suddenly now, quote, the benefits and entitlements arising from the plaintiff's contractual agreement and the ability to repair or replace the wall that the defendants have admitted liability for. They've shown no interest in litigating this matter. They've shown no interest in fixing this wall. They want to fix the wall now because they want to reopen discovery and do things that they should have done 2 years ago when this litigation commenced. The black and white terms of the counterclaims provide no basis for anything other than a futility argument. And so based on those points, Your Honor, we would ask that the motion to amend be denied, even though we have an extension with regard to the scheduling of the trial. They should not be able to benefit from doing nothing in this case while plaintiff has incurred attorney's fees and costs, complying with all of the rules, all of the deadlines, building a case. They've done nothing, and now they ask for this court's grace for a third time after they filed numerous motions asking to reopen discovery, reopen motion practice, etc. It's outrageous, and it should be utterly rejected.
What about the fact that, well, the argument that was made that these are claims that are concerning the same parties, the same set of events, such that they're likely mandatory counterclaims, and if you tried to raise them in a separate proceeding, they'd be subject to dismissal.
Right. That may very well be true. It would need a judge's determination, but judge, again, that's something that their former counsel should have reckoned with 2 years ago when this action was brought. They should have filed an answer and a counterclaim. Just like if I was a defendant and less than 2 months before trial, I wanted to assert various affirmative defenses that I didn't include in my answer from 2 years earlier, I don't think a court would grant that right. There has to be some repose, some deadlines, some resolution with regard to a case. My client has has acted within the scope of all of the rules, all the procedural guidelines. Defendants have done utterly nothing with regard to this case. I can't help that they may have a claim that they've discovered now that they should have asserted years ago. As a matter of fact, the record is clear. I've submitted communication to Your Honor as exhibits with regard to the response to the motion, which indicate that before this litigation ever commenced, Mr. Johnson was reaching out via text, via email, talking to these folks, trying to get them to do anything to fix this wall, and they did nothing. They've known about these facts. They've had a counsel since the inception of this litigation who understands the concepts of mandatory counterclaims. They didn't do anything. They can file another lawsuit, but the claim that the suggestion that claims have to be introduced even at the 11th hour before trial because they might be mandatory counterclaims is spurious at best. It's just not credible.
Why wouldn't it be a better course for the court to allow amendment and then to consider the arguments that you've presented about defendants not having done anything for years, in the context of damages to your clients and attorney's fees regarding the claims raised in your client's complaint? Well,
it rewards conduct which is diametrically black and white oppositional to the Arizona rules of civil procedure. It would reward someone who didn't do any discovery, wait until the 11th hour, and then asserted some argument regarding mandatory counterclaims as a basis by which to reopen the discovery in the case, get experts and that sort of thing. The court could award attorney's fees, obviously, but we've been in compliance with all the rules, and defendants find themselves now in this predicament. They've known about and threatened to try to amend the counterclaims since, I believe, February of 2026. So there's a concept in the law, Your Honor, regarding latches and sitting on your hands, undue delay. This case is a complete example of undue delay, which brings detriment and prejudice to my client, and exposes them to significant prejudice, as I indicated.
If the court's if disclosure discovery would be reopened to the limited claims brought in the counterclaim, I mean, disclosure discovery has already been closed in regards to your plaintiff's claims. What is the other prejudice? What is the prejudice incurred by your clients?
The prejudice would be expending attorney's fees, funds, and experiencing further delay with regard to the resolution of this case. As I indicated there before, there has to be some repose at some point with regard to the resolution of litigation. We followed the deadlines. They're almost a year old by now, if not more. We've acted in accordance with all of the rules. Defendants have filed various motions to reopen items because they haven't done anything in the case. I'm repeating myself now, so I apologize, but the prejudice would be the ongoing delay with regard to the case, attorney's fees and costs incurred in that regard as well. And then litigating over utterly futile claims that have no merit, that would be subject to further dispositive motion practice, resulting further attorney's fees and costs to my client. It would be rewarding the defendants for intransigence and sitting on their hands for a number of years, and then giving the benefit of an entirely new scope of litigation at the 11th hour.
I guess one last question before I go back to Mr. Kazi is, I'm a little concerned that the issue's been raised late by defendants, as you point out, in regards to their delay in getting in cooperating to get the wall fixed. But then once they did try to get the wall fixed, plaintiffs have now allegedly not cooperated with trying to get the wall fixed. And it seems a little bit as if they're doing it out of being upset that it's taken so much delay. And so I'm concerned that I may be conflating one sense of delay for another sense of delay if I were to find that there's been undue delay. I know that probably, I'm concerned that the delay that the defendants have made prior to responding to the request for the repair is not the same as the delay that's occurred since the request for the repair was made and then it was denied and they raised their claim.
Suggesting that plaintiffs have engaged in longer or worse delays than the defendants have. Is that the suggestion?
No, not that not that your clients have engaged in worse delay than the defendants, just that the two delays are different.
Okay. We have obtained expert opinion with regard to the proper scope and repair of the wall. That expert opinion conflicts with the opinion. It's not an expert opinion, but the opinion that was produced by defendants only a couple of months ago. The scope of repair that we are proposing includes water membranes, etc., and expands on the scope of repair that defendants want to employ. Number one. Number two, there was a lot of talk about the accrual of the action. The accrual of the action happened 4 years ago, not several months ago. They could have come into the backyard at any point. Number three, we have litigation. We're going to go to trial and appear before Your Honor, and Your Honor is going to make a determination with regard to the proper scope of the repair to the wall. There's no second litigation that would be necessary for defendants. Utterly futile. This litigation will resolve all of the issues in this case, including other ancillary damages, which plaintiff has, which can be carved out, obviously. But this litigation is going to address the proper repair protocol for the wall, such that there will be nothing thereafter to adjudicate. In other words, the subject matter of this litigation, the vast majority of the subject matter is the repair protocol for the wall. All issues that are being raised by Mr. Causey and he is desirous of including in a counterclaim will be resolved all at the same time.
Thank you, Mr. Causey.
Yeah, I don't see how in this trial, if we don't have the counterclaim, my client's damages claims are going to get resolved. Maybe counsel can explain that because I don't see it. So I'm a little confused by that assertion.
Sure,
Let
Mr. Causey,
me
you just
ask,
indicated
well,
you
hold
don't
on,
have
hold on, hold on, hold on.
damages.
Let me hear from Mr. Causey. Mr. Causey, Mr. Connolly there towards the end raised an interesting point to me. Currently, as things stand, they have an expert opinion that's going to testify about the repair to this wall, and you have not disclosed an expert opinion that's going to testify to the repair to the wall. And his argument is that this counterclaim is going to allow you to now get in an expert opinion that you otherwise wouldn't be able to present if I didn't allow your counterclaim.
Your Honor, counsel's misrepresenting to the court. My client months ago, I think last year, has offered to repair the wall. And then when that was refused because of all these ancillary arguments being made by counsel on behalf of the plaintiff to just derail us from fixing the wall, we submitted all the membrane stuff, all the landscaping. We submitted, I don't know what it was, how many thousands of dollars. But when that was all refused, we then offered to pay their contractor to fix it. Okay, we just wanted the wall fixed. Okay,
So let
we
me
offered to
let me
pay
get some
that.
clarification from you then, Mr. Causey, because when we spoke earlier about what potential disclosure discovery would be added by your counterclaim, you had stated a witness from the HOA regarding approving the repair, and then you stated an additional witness regarding damages. You said a real estate agent?
Yeah.
Okay.
Yeah. No fence person, no contractor.
And what's the scope of testimony from the real estate agent?
My clients have been trying to sell their home and they're currently still losing buyers because of they can't get the wall fixed. And the exact extent of those damages, I don't know yet because we haven't fully investigated it yet, but I will in time for a disclosure in this matter. If it's added to this case, if I have to file a separate suit and then move to consolidate, we'll still comply with the disclosures in that. The whole problem here is my client's legal claim under the law did not accrue until two things happened. And this is all in compliance with the CC&Rs, the contract that the court has already ruled governs the relationship between the plaintiff and the defendants. Until they get it approved, a repair approved by the HOA, which they did, and that was their contractor's submittal, which Mr. Connolly has pointed out his client rejects, even though the HOA's approved it. And the second thing that had to happen to get a cause of action to accrue was plaintiff had to refuse reasonable access to their property to allow the repairs. Till those two things happen, there's no cause of action. None. And I don't really understand. I mean, as I mentioned earlier, all this, well, we wanted it repaired a long time ago. Your Honor, I got a demand from plaintiff in response to our request to allow the repair.
Don't share the
I got a
subject
demand
matter.
from plaintiff.
Wait.
Negotiations with the court. Wade, what's the matter with you?
It's not, yeah. Rule 68 says for the purposes of determining liability, not for other purposes.
Well, hold on. I don't know if this is going to be fruitful for
It's part of the
my
delay
need to rule
argument.
on the motion, especially if I'm going to be sitting as the trial, a bench trial in this. Let's just not cross that line.
The problem is, Your Honor, it's part of the delay argument. You're asking questions about the delay. They're arguing delay. I'm giving my response to the delay argument. And it has to do with their continued demands that were tagged on to just fixing the wall that made no sense and we completely disagreed with. There is no delay on my client's part. If they had just wanted the wall repaired and only the wall repaired, that probably would have been done a long time ago. It was the tag-ons. Okay, and one of them just came a few months ago and had actually been taken care of 9 months earlier.
Okay.
So it makes no sense. I don't understand we didn't take depositions or send interrogatories. It's a damages claim. It's a cross-examination of their
Well,
witnesses.
It hasn't always been a damages claim.
Yeah, you disputed liability
Well,
for
hold
years,
on.
Wade.
I'm only going to hear
Your Honor,
one side at a time. Mr.
Can we
Connolly.
deal with the court, and can counsel
Well,
not direct those comments to me like that? That was a direct confrontation.
Well, okay, let me
That's
let me
improper.
say this. Let me pause this really quick because we have Miss Stark in here. And I just wanted to address her really quickly. Miss Stark, I know you're here for a 10:30, but what happened with the 10:30, Crystal? It got continued for a new scheduling order, correct?
We filed a notice of settlement, Your Honor, on
Oh, that's what it
Friday.
was. Notice of
Yeah, I
settlement.
just wanted to appear and make sure that I saw it was docketed, but no minute entry. So just wanted to show my little icon on the screen.
Okay, we did receive it, Miss Stark. We received the notice of settlement. So an email should have went out that we were going to vacate the trial setting conference. But thank you for your appearing. You're free to go if you'd like.
Perfect. Thank you, Your Honor.
All right.
Take care.
Thank you. Okay.
And there are a few more arguments I'd like to address if the court would allow me.
I don't think I'll need you to, Mr. Causey.
Okay, Your
I'd-
Honor. I
I'd like to-
would like to clear the record a little bit though, but that's fine.
I'd like to reference one more point, Your Honor. On November 21st, 2025, before Thanksgiving of last year, the court denied the motion to reopen discovery, denied the motion for additional motions for summary judgment. That's the law of the case. That was almost a year ago now. I
Okay,
just offer that.
thank you.
And as I indicated in my response, it seems like this is a backhanded effort to reopen discovery, and that's exactly what Mr. Causey confirmed this morning.
All right. I don't see it that way. I'm inclined to grant the motion to amend. But it's not going to be, I'm not going to allow additional discovery in terms of anything that's been raised in the plaintiff's complaint or anything that's been already determined by the motion for summary judgment. It will be very narrow to the two witnesses you've discussed today, Mr. Causey. No, I would not be likely to permit any witnesses outside of the two that you've discussed today, because I do believe that if it does get into the realm that Mr. Connolly discussed in terms of an additional expert witness that would run contrary to their expert witness, then that would be much more prejudicial than the scope that you had discussed with me today during the hearing, Mr. Causey.
I agree, Your Honor, but the court asked me what I anticipated. I obviously have not seen their disclosure to the counterclaim. So whether additional witnesses are needed or they expand it beyond that, I think it's too early to draw a hard line. My representation to the court is still correct. I just don't want it to be taken as a stipulation on my client's part that that's all, and somehow be argued down the road by Mr. Connolly that we'd previously agreed to that.
Okay, well, if it needs to be addressed in a discovery dispute, then it can, but I will let you know that on future review, it's going to be a pretty tight interpretation here, because I do give effect to the prior rulings denying reopening discovery and disclosure, as well as the proper scope that I'm finding would not be prejudicial in allowing the amendment, in considering both the prejudice under Rule 15, as well as the fact that amendment is to be freely given. I don't believe that otherwise that this is going to cause too much of a delay my real concern is how much new disclosure discovery this is going to open up. And based on the assertions that you've made at this point, I will find that the prejudice isn't such that I'm going to deny the motion to amend, but it's going to be a pretty tight scope that I'm gonna permit.
To be clear, Your Honor, you're allowing defendants to introduce expert opinion regarding real estate issues and their inability to sell the house. Is that what you're saying?
I'm going to allow testimony regarding their claims, whatever their damages are for selling the house, but it's not going to be to contradict your expert on the wall that you've discussed.
And so the plaintiff will also have to now secure new expert opinion to rebut those arguments, and we're essentially starting from square one.
No, I don't think we are starting from square one, but I recognize your point.
So, Your Honor, are we scheduling the trial date then? And by the way, the counterclaim, my client's still in agreement to the bench trial versus that moving us into a jury trial setting. So we're still agreement with that, as long as Mr. Connolly is.
And Mr. Connolly, if you want to speak with your clients about that, you may.
I have to, yes.
Okay.
Should we set a trial setting conference in a few days, then maybe after? And whatever they decide, I don't think my client's going to object either way, but
we'll have to circulate a proposed scheduling order for deadlines for counter claimants, expert deadlines, and defendants' expert deadlines. I'll have to depose their expert and their witnesses. So I'll say again, Judge, it sounds like we're rather starting from square one here. So I don't even know if a trial date setting is appropriate at this point, or that one can be conducted in 2026. I mean, it sounds like there's going to be a lot of discovery about a lot of specious arguments involving the sale of a house.
Well, regardless of whether I permitted the amendment, I don't think that I had room in my calendar for something in 2026.
I think we can get
So
together.
we can proceed in one of two ways. We can reconvene after you speak with your clients, Mr. Connolly, about if you want to proceed forward with a bench trial or a jury trial. We can have another status conference in 2 weeks or a week to discuss what your clients would like to do. Alternatively, you can just submit a new, well, you'll have to have a new scheduling order to address the limited disclosure and discovery I'm going to allow on the counterclaim, and then we can just reconvene to discuss that and set a new trial at that time. What would you like to do, Mr. Connolly?
I would ask Mr. Causey to submit a proposed scheduling order to me for my approval, and I'll approve or reject it as necessary, and then we can get it with the court.
Okay.
And really sincerely hope the court recalls this entire episode when it comes time to award attorney's fees.
Right. I mean, like I stated during your argument, I really do see this as two separate issues, and to the extent that there was delay at any point leading up to today, those are arguments you still have well preserved for your request for attorney's fees.
Very well.
Okay. Mr. Causey,
Yes, sure.
can you get a proposed schedule? If I order you to have the proposed scheduling order to Mr. Connolly by 8/21, will that be sufficient time?
Oh, absolutely, Your Honor.
And Mr. Connolly,
have it for that.
will that be sufficient time for you to speak with your clients so that
Yes.
you can? Okay. So I'll order that the new scheduling order be submitted to the court by 8/21. I'll put this case,
To the court
What's-
by 8/21 or to Mr. Conley?
uh,
I'm sorry.
I'm sorry, to Mr. Conley by 8/21 and then to the court by 8/28.
Oh, yes, Your Honor. Okay. Thank you.
And then once
Your
I
Honor,
receive that,
Should we
once I
submit?
receive that, I would like that to include whether it's going to be a bench trial or a jury trial. And then once I receive that, then I'll set a new scheduling conference for us to get something on the schedule so that there won't be any further delay than there needs to be.
And Your Honor, should we submit possibly a supplemental joint report addressing the counterclaim as well?
No, I don't
Okay.
think I'll need a supplemental. Are you talking about a joint scheduling report or a joint
Yeah, the Rule
pre-trial
16
report?
No, the joint report.
No,
we'll
I
need-
don't
We'll
think
need
I'll
a
need a
pre-trial,
new-
yeah.
I don't think I'll need a new joint
Okay.
scheduling report,
Okay.
unless you disagree, Mr. Connolly.
Yeah.
Okay. Okay.
Okay. Thank you, Your Honor.
Is there anything else that may be a benefit to discuss, Mr. Causey,
Not at this point that I can think of, Your Honor.
Mr. Connolly?
Nothing, Your Honor.
Okay. And let me ask, one of the things we had discussed at our last status conference was a possible settlement conference with another judicial officer. Is this something that you'd like me to reach out to other judicial officers about? Maybe wait until after the scheduling order? What are your thoughts, Mr. Causey?
I think the issues are pretty clear amongst the parties. I think it's been exchanged, even on the counterclaim. I mean, there are some witnesses that need to be identified. We're open to that. And I'm not sure. I'd like to get our damages calculations in order before the timing of that, though.
Yeah, that would be a bit of a speed bump.
Okay, so what are your thoughts, Mr. Connolly, then?
No, we're not interested in that. And this 11th hour posturing and this damages, we're not interested in any of that.
I'm curious, would counsel want to consult his client first, possibly?
Well,
I've
he can
already
consult
talked
his
to-
client, but if they don't want to, I'll take him for what he's saying right now.
Okay.
Wade, you know, we've
Your Honor.
discussed settlement numerous times.
Okay. All right, anything else before we adjourn, Mr. Causey?
No, Your Honor.
Mr. Connolly?
No.
All right. All right, then we'll adjourn at this time. Thank you for your appearances today. I hope you have a good rest of your day. Thank you.
Thank you, Your Honor.